now continue my reading of the judgment in English. The court recalls that its role under Article 60 of the statute is to clarify the meaning and scope of what the court decided in the judgment which it is requested to interpret. Accordingly, the court must keep strictly within the limits of the original judgment and cannot question matters that were settled therein with binding force, nor can it provide answers to questions the court did not decide in the original judgment. In determining the meaning and scope of the operative clause of the original judgment, the court, in accordance with its practice, will have regard to the reasoning of that judgment to the extent that it sheds light on the proper interpretation of the operative clause. The pleadings and the record of the oral proceedings in 1962 are also relevant to the interpretation of the judgment, as they show what evidence was or was not before the court and how the issues before it were formulated by each party. Thailand argues that the principle of non ultra petita precluded the court from going beyond the submissions of the parties, and that the 1962 judgment must be interpreted accordingly. The principle of non ultra petita is well established in the jurisprudence of the court, and is one reason why the claims contained in the final submission of the parties in the original case are of relevance in interpreting the 1962 judgment. Nevertheless, that principle cannot justify an interpretation which runs counter to the terms of the 1962 judgment. The court in 1962 necessarily made an assessment of the scope of the petitum before it. Article 60 of the statute does not give the court the power today to substitute a different assessment for that made at the time of the judgment. Cambodia suggests that the head note to the 1962 judgment demonstrated that the judgment determined the scope of the frontier in the relevant area. Under Article 95, Paragraph 1 of the Rule of Court, at the time of 1962 judgment on Article 74, Paragraph 1 of the Rules of Court of 1946 was applicable. The head note is not one of the elements of the judgment, and it does not form part thereof. Moreover, the purpose of the head note is only to give the reader a general indication of the points examined in a judgment. It does not constitute an authoritative summary of what the court has actually decided. The court does not consider that the head note to the 1962 judgment assists in resolving the questions of interpretation raised in the present proceedings. Thailand makes extensive reference to the conduct of the parties between 15 June 1962, when the judgment was delivered, and 2007-2008, when the present dispute may be said to have crystallized. Thailand suggests that this conduct is inter alia relevant to the interpretation of the judgment. The judgment of the court cannot be equated to a treaty, an instrument which derives its binding force and content from the consent of the contracting states, and the interpretation of which may be affected by the subsequent conduct of those states is provided by the principle stated in Article 31, Paragraph 3b of the 1969 Vienna Convention on the Law of Treaties. The judgment of the court derives its binding force from the statute of the court, and the interpretation of a judgment is a matter of ascertaining what the court decided, not what the parties subsequently believed it has decided. The meaning and scope of a judgment of the court cannot, therefore, be affected by conduct of the parties occurring after that judgment has been given. More generally, as the Permanent Court of International Justice made clear, and I quote, the court, when giving an interpretation, refrains from any examination of facts other than those which it has considered in the judgment under interpretation. End of quotation. Three features of the 1962 judgment stand out when the judgment is read in the light of the considerations set out above. First, the court considered that it was dealing with a dispute regarding territorial sovereignty over the area in which the temple was located, and that it was not engaged in delimiting the frontier. Thus, the court, referring back to its 1961 judgment on preliminary objections, characterized the dispute as one regarding sovereignty over a defined area of territory rather than boundary delimitation. It is also evident in the court's decision that, and I quote, Cambodia's first and second submissions calling for pronouncements on the legal status of the Annex I map and on the frontier line in the disputed region can be entertained only to the extent that they give expression to grounds and not as claims to be dealt with in the operative provisions of the judgment. End of quotation. No mention was made of either the Annex I map or the location of the frontier in the operative part. No map was attached to the judgment, nor did the court make any comment on the difficulties of transposition of the Annex I map line, a matter which had been discussed by the parties during the 1962 proceedings and which would have been of obvious importance in a judgment on the limitation of the frontier. Secondly, however, the Annex I map played a central role in the reasoning of the court. After reviewing the history of the map and its relationship with the 1904 treaty, the court stated, and I quote, "The real question, therefore, which is the essential one in this case, is whether the parties did adopt the Annex I map and the line indicated on it as representing the outcome of the work of the delimitation of the frontier in the region of Preah Vihear, thereby conferring on it a binding character." End of quote. He then considered the conduct of the parties with regard to the map and other practice, including the visit of Prince Damrong to the temple in 1930, when he was received by the French authorities. Although the court considered that the circumstances of Prince Damrong's visit were such as to amount to a, and I quote, "tacit recognition by Siam of the sovereignty of Cambodia and the French protectorate over Preah Vihear," end of quote, that incident, together with Thailand's other conduct subsequent to 1908-1909, was treated primarily as confirmation of the earlier acceptance by Thailand of the Annex I map line. The court considered that, and I quote, "Thailand in 1908-1909 did accept the Annex I map as representing the outcome of the work of delimitation, and hence recognized the line on the map as being the frontier line, the effect of which is to situate Preah Vihear in Cambodian territory." End of quotation. The court went on to state that, and I quote, "the acceptance of the Annex I map by the parties caused the map to enter the treaty settlement and to become an integral part of it," end of quotation, and concluded that it, quote, "therefore feels bound, as a matter of treaty interpretation, to pronounce in favor of the line as mapped in the disputed area," end of quotation. Thirdly, in defining the dispute before it, the court made clear that it was concerned only with sovereignty in the region of the Temple of Preah Vihear. That this region comprised only a small area is apparent from the 1962 proceedings. Thus, counsel for Cambodia stated that, and I quote, "the area in dispute in these proceedings is very small, indeed." End of quote. These and other similar statements were not contradicted during the 1962 proceedings. The judgment shows that the court considered that the disputed area was a small one. Immediately after the passage in which defined the dispute as one regarding sovereignty over the region of the temple, the court described that region in the following terms. And I quote, "The Temple of Preah Vihear stands on a promontory of the same name, belonging to the eastern sector of the Dangrek range of mountains, which, in a general way, constitutes the boundary between the two countries in this region, Cambodia to the south and Thailand to the north." End of quote. While the Annex 1 map deals with a part of the frontier region more than 100 kilometers in extent, the court made clear that it had to pronounce upon it only in the disputed area. In the light of these elements, the reasoning of the 1962 judgment, the court turns to the operative part of the judgment. The findings set out in the second and third paragraphs are expressly stated to be consequences following from the decision in the first operative paragraph. It follows that the three operative paragraphs have to be considered as a whole. The task of ascertaining their meaning and scope cannot be reduced to an exercise of construing individual words or phrases in isolation. The court considers that the meaning of the first operative paragraph is clear. In that paragraph, the court ruled on Cambodia's principal claim by finding that the temple was situated in territory under the sovereignty of Cambodia. It states, however, that it will be necessary to return to the scope of this paragraph once the court has examined the second and third operative paragraphs. The principal dispute between the parties concerns the second operative paragraph. In that paragraph, the court required, as a consequence of the decision in the first operative paragraph, the withdrawal of Thai military or police forces or other guards or keepers stationed by her at a temple or in its vicinity on Cambodian territory. The second operative paragraph did not indicate expressly the Cambodian territory from which Thailand was required to withdraw its personnel, nor did it state to where those personnel had to be withdrawn. The only context in which the paragraph refers to an area of territory, quote, "the temple or its vicinity on Cambodian territory," end of quote, was in indicating which of its personnel Thailand was under an obligation to withdraw, namely those whom it had stationed in that area. Since the second operative paragraph of the 1962 judgment required Thailand to withdraw any of its military or police forces, or other guards or keepers stationed by her at the temple or in its vicinity on Cambodian territory, the court considers that it must begin by examining the evidence that was before the court in 1962 regarding the locations at which such Thai personnel were stationed. The only such evidence was given by Professor Ackerman, who was called by Thailand as an expert and witness, and who had visited the temple for several days in July 1961 in the course of preparing a report to be submitted in the proceedings. Under cross-examination by counsel for Cambodia, Professor Ackerman testified that during that visit, the only people he had seen at the Preah Vihear promontory were a detachment of Thai frontier police and one temple guard. He stated that the police had been stationed in blockhouses at a camp located to the northeast of the temple, while the guard had lived in a separate house a short distance to the west of the police camp. The location of the police station was subsequently confirmed by counsel for Thailand, according to whom the police camp was located south of the Annex 1 map line, but north of a line which Cambodia maintained was the watershed line. During the 1962 proceedings, Cambodia had advanced an alternative argument that if, contrary to its primary position, the boundary was required to follow the watershed rather than the Annex 1 map line, then it was this Cambodian line which represented the watershed and not the watershed line advocated by Thailand, to which reference had already been made. In the event, the court found that it was unnecessary to consider the location of the watershed in the area of the temple. Nevertheless, the reference to that line in the speech by Council for Thailand is significant, because as Thailand has stated in the current proceedings, the Thai Council of Ministers line follows a course very close to that of the watershed line advanced by Cambodia in 1962. It is apparent, therefore, that the Thai police detachment was stationed at the location north of the line subsequently drawn by the 1962 resolution of the Thai Council of Ministers, and thus outside what Thailand considers to be, and I quote, vicinity of the temple in the Cambodian territory. End of quote. When the court required Thailand to withdraw military or police forces, guards or keepers, which it had stationed in the temple or in the vicinity of the temple on Cambodian territory, it must have intended the obligation to apply to the police detachment referred to by Professor Ackerman, since, except for the solitary temple guard, who seems to have been living near the police camp, there was no evidence of the presence of any other Thai personnel anywhere near the temple. Accordingly, the term, quote, vicinity on Cambodian territory, quote, has to be construed as extending at least to the area where the police detachment was stationed at the time of the original proceedings. Since that area lies north of the Thai Council of Ministers line, that line cannot represent the correct interpretation of the territorial scope of the second operative paragraph, as Thailand contends. That conclusion is confirmed by a number of other factors. As the court emphasized in its description of the area around the temple is located on an easily identifiable geographical feature. This feature is a promontory. In the east, south, and southwest, the promontory descends by a steep escarpment to the Cambodian plain. In the west and northwest, the ground drops into what Professor Ackerman described in his evidence as a valley between the Phnom Prap mountain and the Preah Vihear mountain. It is through this valley that access to the temple from the Cambodian plain can most easily be obtained. The hill of Phnom Prap rises from the western side of this valley. A natural understanding of the concept of the vicinity of the temple would extend to the entirety of the Preah Vihear promontory. Furthermore, the court's reasoning regarding the significance of the Annex 1 map shows that the court considered that Cambodia's territory extended in the north as far as, but no farther than, the Annex 1 map line. Although Professor Ackerman did not give any estimate of the distances between the various places on the promontory to which he referred in his evidence, it is clear that, for example, the police post which he identified was only a very short distance to the south of the nearest point on the Annex 1 map line. The court was therefore dealing with a small area with clearly defined geographical limits to the east, southwest, and northwest, and bounded in the north by what the court had stated in its reasoning was the limit of Cambodian territory. In these circumstances, the court considers that the territorial scope of the second operative paragraph must be construed as extending to the whole of the promontory, rather than being confined to that part of it chosen by the Thai Council of Ministers in 1962. Turning to the position of Cambodia, the court is also unable to accept its interpretation of vicinity. In its answer to the question put by a member of the court, Cambodia maintained that the vicinity includes not only the promontory of Preah Vihear, but also the hill of Phnom Trap. There are several reasons why the court considers that this is not the correct interpretation of the second operative paragraph. First, Phnom Trap and the promontory of Preah Vihear are distinct geographical features which are clearly shown as separate on the maps used in the 1962 proceedings, and in particular on the Annex 1 map, which was the only map to which the court made more than passing reference in the judgment. Secondly, there are certain indications in the record of 1962 proceedings that Cambodia did not treat Phnom Trap as falling within the, quote, region of the temple, or temple area, the terms used by the court in defining the scope of the dispute. Thus, a former Cambodian provincial governor, Mr. Suon Bon, who was called as witness by Cambodia, testified that Preah Vihear had formed part of his province, but that he saw that Phnom Trap belonged to a neighboring province. Moreover, as explained above, when referring to the area with which the court was concerned, counsel for Cambodia spoke of dimensions in terms which would be too small to encompass at the same time Phnom Trap as well as the promontory of Preah Vihear. He also stated that Phnom Trap was not part of the crucial area with which the court was concerned. Thirdly, there was no evidence before the court of any Thai military or police presence on Phnom Trap in 1962, and no suggestion that Phnom Trap was relevant to Cambodia's claim that Thailand should be required to withdraw its forces. Lastly, Cambodia's interpretation depends upon identifying the location of the points with the Annex 1 map line intersects with the watershed line advocated by Thailand. Yet, in the 1962 judgment, the court made clear that it was not concerned with the location of the watershed and did not decide where the watershed lay. It is therefore implausible to suggest that the court had the watershed line in mind when it used the term vicinity. While no one of these considerations is conclusive in itself, taken together, they lead the court to conclude that in 1962, the court did not have this wider area in mind, and accordingly, that it did not intend the term vicinity of the temple in Cambodian territory to be understood as applicable to territory outside the promontory of Preah Vihear. That is not to say that the 1962 judgment treated Phnom Trap as part of Thailand. The court did not address the issue of sovereignty over Phnom Trap or any other area beyond the limits of the promontory of Preah Vihear. From the reasoning in the 1962 judgment, seen in the light of the pleadings in the original proceedings, it appears that the limits of the promontory of Preah Vihear to the south of the Annex 1 map line consist of natural features. To the east, south and southwest, the promontory drops in a steep escarpment to the Cambodian plain. The parties were in agreement in 1962 that this escarpment and the land at its foot were under Cambodian sovereignty in any event. To the west and northwest, the land drops in a slope, less steep than the escarpment, but nonetheless pronounced, into the valley which separates Preah Vihear from the neighboring hill of Phnom Trap, a valley which itself drops away in the south to the Cambodian plain. For the reasons already given, the court considers that Phnom Trap lay outside the disputed area. The 1962 judgment did not address the question whether it was located in Thai or Cambodian territory. Accordingly, the court considers that the promontory of Preah Vihear ends at the foot of the hill of Phnom Thap, that is to say, where the ground begins to rise from the valley. In the north, the limit of the promontory is the Annex 1 map line, from a point to the northeast of the temple, where that line abuts the escarpment to a point in the northwest, where the ground begins to rise from the valley at the foot of the hill of Phnom Thap. The court considers that the second operative paragraph of the 1962 judgment required Thailand to withdraw from the whole territory of the promontory, thus defined, to Thai territory any Thai personnel stationed on that promontory. The court notes Thailand's argument about the difficulty of transposing the Annex 1 map and thus of ascertaining the precise location on the ground of the Annex 1 map line in the area described in the preceding paragraph. The 1962 judgment did not, however, address that question, and the court cannot now, in the exercise of its jurisdiction under Article 60, to interpret the 1962 judgment, deal now with a matter which was not addressed by the judgment. Nevertheless, the parties to a case before the court have an obligation to implement the judgment of the court in good faith. It is of the essence of that obligation that it does not permit either party to impose a unilateral solution. The court recalls that the three paragraphs of the operative part of the 1962 judgment have to be considered as a whole. Having determined the meaning and scope of the second paragraph, the court now turns to the relationship between that paragraph and the other two paragraphs of the operative part. While there is no dispute within the parties regarding the third operative paragraph, it is nonetheless relevant to the extent that it sheds light on the meaning and scope of the rest of the operative part. The scope of the operative part of the judgment of the court is necessarily bound up with the scope of the dispute before the court. The 1962 judgment defined the dispute which was then before the court as one concerning, and I quote, sovereignty over the region of the Temple of Preah Vihear. It was entirely consistent with this view of the dispute that the court, having decided in the first operative paragraph of the judgment that the temple was located in territory under the sovereignty of Cambodia, determined, as a consequence of that finding, that Thailand was under an obligation to withdraw its forces and other personnel stationed at the temple or in its vicinity on Cambodian territory, and to restore objects removed from the temple or the temple area. The second and third operative paragraphs each, therefore, impose obligations with respect to an area of territory which extended beyond the temple itself. The second operative paragraph expressly described this area as Cambodian territory. The third operative paragraph did not do so, but the court considers that such a description was implicit. An obligation to restore artifacts taken from the area of the temple would be a logical consequence of a finding of sovereignty only to the extent that the area in question was covered by that finding. The area with which the court was concerned in the original proceedings, as has already been explained, is small and bounded, except to the north, by readily identifiable geographical features. In these circumstances, the court considers that the terms vicinity of the temple on Cambodian territory in the second paragraph and area of the temple in the third paragraph refer to the same small parcel of territory. The obligations which the court imposed in respect of that parcel of territory were stated to be a consequence of the finding in the first paragraph. In view of the characteristics of the dispute which confronted the court in 1962, in particular the nature of the submissions of each party, the obligations imposed by the second and third paragraphs would be a logical consequence of the finding of sovereignty in the first operative paragraph only if the territory referred to in the first paragraph corresponded to the territory referred to in the second and third. Accordingly, the court concludes that the territorial scope of the three operative paragraphs is the same. The finding in the first paragraph that the Temple of Preah Vihear is situated in territory under the sovereignty of Cambodia must be taken as referring, like the second and third paragraphs, to the promontory of Preah Vihear within the limits described in paragraph 98 of the present judgment. In these circumstances, the court does not consider it necessary further to address the question whether the 1962 judgment determined with binding force the boundary line between Cambodia and Thailand. In a dispute concerned only with sovereignty over the promontory of Preah Vihear, the court concluded that that promontory, extending in the north to the Annex 1 map line, but not beyond it, was under Cambodian sovereignty. That was the issue which was in dispute in 1962, and which the court considers to be at the heart of the present dispute over interpretation of the 1962 judgment. Nor is it necessary for the court to address the question whether the obligation imposed in Thailand by the second operative paragraph was a continuing obligation in the sense maintained by Cambodia. In the present proceedings, Thailand has accepted that it has a general and continuing legal obligation to respect the integrity of Cambodian territory, which applies to any disputed territory found by the court to be under Cambodian sovereignty. Once a dispute regarding territorial sovereignty has been resolved and uncertainty removed, each party must fulfill in good faith the obligation which all states have to respect the territorial integrity of all other states. Likewise, parties have a duty to settle any dispute between them by peaceful means. These obligations, which derive from the principles of the Charter of the United Nations, are of particular importance in the present context. It is clear from the record of both the present proceedings and those of 1959-1962, the Temple of Preah Vihear is a site of religious and cultural significance for the peoples of the region and is now listed by UNESCO as a World Heritage Site. In this respect, the court recalls that under Article 6 of the World Heritage Convention, to which both states are parties, Cambodia and Thailand must cooperate between themselves and with the international community in the protection of the site as a World Heritage. In addition, each state is under an obligation not to, and I quote, take any deliberate measures which might damage directly or indirectly such heritage. In the context of these obligations, the court wishes to emphasize the importance of ensuring access to the temples from the Cambodian plain. The court therefore concludes that the first operative paragraph of the 1962 judgment determined that Cambodia had sovereignty over the whole territory of the promontory of Preah Vihear, as defined in paragraph 98 of the present judgment, and that, in consequence, the second operative paragraph required Thailand to withdraw from that territory the Thai military or police forces or other guards or keepers that were stationed there. I shall now read out paragraph 108, which contains the operative clause of the judgment. For these reasons, the court, 1. Unanimously finds that it has jurisdiction under Article 60 of the Statute to entertain the request for interpretation of the 1962 judgment presented by Cambodia, and that this request is admissible. 2. Unanimously declares by way of interpretation, that the judgment of 15 June 1962 decided that Cambodia had sovereignty over the whole territory of the promontory of Preah Vihear, as defined in paragraph 98 of the present judgment, and that, in consequence, Thailand was under an obligation to withdraw from that territory the Thai military or police forces or other guards or keepers that were stationed there. Veuillez vous asseoir on the registrar to read the operative clause of the judgment in French. Vous avez la parole, monsieur le greffier.
Par ces motifs,
Nous allons entendre la suite du premier tour de plaidoirie du royaume
dit que la compétence, en vertu de l'article 60 du statut, pour connaître de la demande en interprétation de l'arrêt de 1962 présenté par le Cambodge et que cette demande est recevable. 2. L'unanimité déclare, à titre d'interprétation de l'arrêt du 15 juin 1962.
Monsieur le Président, Mesdames,
dans
Messieurs les membres de la Cour,
décider que le Cambodge
il me revient désormais pour clore cette journée de plaidoirie d'expliquer ce qui constitue sans doute le cœur de la contestation de la requête du Cambodge.
La Thaïlande était tenue pour retirer
À savoir la question de la lecture isolée du dispositif de l'arrêt du 15 juin 1962, d'où découlent de multiples conséquences.
Judges,
Amène justement le Cambodge à revenir devant votre cour.
the judgment of the court.
Le Cambodge tient à préciser de nouveau qu'il souhaite s'en tenir strictement aux réponses ou absences de réponses au supplément d'information de la Thaïlande du 21 juin 2012.
The text of the judgment is available
Pour
from
cela,
today in Thai script.
il est nécessaire tout d'abord
It will also be
de
available shortly
revenir
on the
sur le
court website.
raisonnement général
The printed
par la
text
Thaïlande,
will be available in the near future.
plutôt sur les points obscurs qui
The court
jalonnent
has no
ce
other business
raisonnement.
before it.
Le
I declare
Cambodge
this in close.
pourra alors expliquer en quoi les motifs sont inséparables de la lecture objective du dispositif de l'arrêt de 1962. Les trois conséquences découlent de cette lecture du dispositif en liaison avec les motifs essentiels de l'arrêt. Premièrement, ceci entraîne l'impossibilité d'une définition unilatérale d'une quelconque ligne frontalière à l'encontre des motifs. Deuxièmement, ceci implique également l'impossible distinction entre conflit territorial et conflit frontalier. Troisièmement, ceci révèle la véritable signification de l'accord du 14 juin 2000. Il sera alors temps de s'interroger sur la manière dont la Thaïlande peut parvenir à justifier une telle négation de la réalité. Et y parvient par une inversion